This first case is Foster versus Foster. It is a 20-minute argument per side. Mr. Krupstadt, you will start, and you can reserve some of that time, or you could try to, but we like you to try and keep track of that yourself. I will let everybody know it's Justice Bernstein's birthday today, so we would appreciate if you'd start by singing him happy birthday before you go into your argument. I'm kidding.
I think that would be kind of cool. I'm kind of into that.
Yeah. You may proceed, Mr. Krupstadt. Thank you for being here.
Thank you, Your Honor, and may it please the court. The trial court's adoption of the offset provisions of the judgment of divorce did not render the judgment void ab initio. The trial court had subject matter jurisdiction over the divorce action, and in particular over the assets of the parties, including defendant's military disability benefits, and the judgment of divorce is subject to res judicata. As Justice Viviano noted, where the court has jurisdiction of the parties and the subject matter, and has the power to make the order or ruling complained of, but its order is based on mistaken view of the law or upon the erroneous application of legal principles, the judgment or order is erroneous as opposed to void for lack of jurisdiction. A judgment of divorce dividing marital property is res judicata and therefore not subject to collateral attack, even if the judgment may have been wrong or vested on subsequently overruled legal principle. Appellee asserts that 38 U.S.C. section 5301, as well as the absolute federal preemption established by the Supreme Court in McCarty, Manziel, and Howell, all stand for the proposition that state courts, by operation of supreme federal law, lose subject matter jurisdiction over cases involving military disability benefits and are precluded from proceeding to judgments, such as the one entered in this case, that are insulated from collateral attack. This assertion is wrong as a matter of law. Neither in McCarty, Manziel, or Howell did the Supreme Court conclude that state courts lack subject matter jurisdiction over retirement or disability pay. In McCarty, the court characterized the issue before it not as whether a state court had jurisdiction to divide military retirement benefits, but whether it could do so pursuant to state community property law rather than federal law. The holding in McCarty that federal law preempted state law in this area simply meant that state courts are bound to apply federal law in determining the character of military benefits. There was no divestiture of jurisdiction. In McCarty, Justice Blackmun, writing for the court, noted, "This court repeatedly has recognized that the whole subject of domestic relations of husband and wife belongs to the states and not the laws of the United States." As Justice Viviano indicated, a clear analysis of Manziel and its procedural history is critical in this matter. In Manziel, Justice Marshall stated, "Because domestic relations matters are preeminently matters of state law, we consistently recognize that Congress, when it passes general legislation, rarely intends to displace state authority in this area." Justice Marshall also recognized, however, that 38 U.S.C. section 3101 presents one of those rare instances where Congress has directly and specifically legislated in the area of domestic relations. The court held that under the Act's plain language, state courts have been granted authority to treat disposable retirement pay as community property. They have not been granted authority to treat total retired pay as community property. On remand, in the case of In re, the marriage of Manziel, the husband argued that the lower court's 1979 judgment was void for lack of subject matter jurisdiction and therefore subject to collateral attack. The issue of the state court's authority to divide military disability pay was never raised in the divorce case. Several years after the decree was entered, the husband filed a collateral attack upon the divorce decree. The order appealed was a denial of the husband's motion to modify the judgment.
Mr. Krupstadt, let me interrupt you and see what questions. I don't want to use up all your time in case there are questions people have for you. And if there are none, we'll get back to your presentation, okay?
Thank you, Your Honor.
Yeah, absolutely. Justice Zahra.
Thank you. Counsel, I find some help here in the 1976 Michigan Court of Appeals case of Marshall versus Consumers Power, which set forth a two-part test for determining what is preempted. The first question in that two-part test is whether Congress has preempted states from legislating or regulating the subject matter of the instant case. How do we determine what's the subject matter of the instant case? Your position is the subject matter is this is a divorce matter, the divorce action. Opposing counsel says the subject matter is the disability benefits at hand. How is it that we're supposed to determine what exactly is the subject matter?
The subject matter is the division of the military benefit, either the pension or the disability benefit in the context of a divorce case. Federal law suggests that the VA has the authority to determine what benefit eligibility exists, whether a veteran is entitled to benefits, to what extent the benefits are going to be paid, the extent of the disability. The state court has no subject matter jurisdiction over that particular type of determination. What the state court does have subject matter jurisdiction over is the family law case, as well as the division of the assets, the determination of the assets and the value, and the equitable distribution of those assets. So we're not suggesting, Justice Zahra, that the state court has the authority to make a determination as to what extent of disability benefits the veteran should receive. What we are suggesting, however, is that the state court does, in fact, have the authority to take that into consideration. And if that's challenged, in other words, if the state court misapplies federal law, the challenge has to be on direct appeal or to avail themselves of the rules of the court rules seeking relief from the judgment. And that exercise of jurisdiction over the matter does not in and of itself deprive the state court of subject matter jurisdiction over that issue. I hope that answers your question.
No, thank you very much.
Justice Viviano.
Sorry, I have no questions.
Justice Bernstein.
Hey, Counselor, good morning and welcome.
Good morning. Happy birthday.
Well, thank you. I just have to, ask this question, and I realize that the action on this case is the jurisdictional issues, but I guess the question I just want to kind of pose to you is a little bit more of a kind of a human question, which is, what concerns should I have, or should the court have? I realize that, the main action lies elsewhere, but I just feel compelled to ask this question. This is an individual who basically was injured by an IED, as you know. So he suffered some pretty catastrophic injuries. He has been listed as permanently disabled, which for all intents purposes means that he is not going to ever have the opportunity to work again because he's permanently disabled. And we're talking about the division of the benefits that basically are given to him because of his injuries as service to the country. And I guess the question I have is that if you could just kind of address any concerns that you have as it pertains to, as you said, the distinction between retirement benefits of sort, but this is disability benefits that go to a person who is permanently disabled and is never going to be able to work again. And that disability arose out of service. And I guess the question I have is, can you just address that issue?
Yes, thank you. And I understand your concern completely. What we also have to take into consideration, Justice Bernstein, is the non-military spouse and the impact that this has on that particular spouse. In other words, they've been the ones waiting at home for the spouse to return. They're the ones that have been taking care of the household, waiting for the spouse to return. And in some cases, they're the ones that provide aid and benefit to the veteran when he does come home within the household. When there's a divorce situation, the availability of military pension, whether it's pension or disability, is taken into consideration in terms of what the income to both parties are going to be when the marriage is dissolved. If the non-military spouse waives spousal support or gives up certain assets in exchange for being awarded a percentage of whatever the benefit may be, he or she subjects herself to potential loss down the road as well. And while I appreciate that the nature of these benefits is to compensate an injured veteran for his or her service to the country, we also have to take into consideration the equities in the court, in the state court, when deciding how to divide the assets between the parties when there is a divorce. I hope that answers and addresses your concern.
It does. Thank you very much. And I have no further questions.
Thank you, Your Honor.
No questions right now. Thank you.
Justice Kavanaugh,
No questions for me.
Justice Welch.
No questions.
Mr. Krupstadt, you may continue or reserve your time.
Thank you, Your Honor. It was in the motion that was appealed in Mansell on remand that the husband first argued that the court lacked authority to divide his disability pay. The California court noted that there is a distinction between preemption occurring when a congressional enactment expressly or impliedly prohibits the state's exercise of jurisdiction over certain subject matter, and the type of preemption that occurs where state law and federal law are so inconsistent that state law must give way because it impedes the accomplishment and execution of Congress's full purpose and objectives. The latter type of preemption requires states to defer their interests under the Supremacy Clause to federal interests, even though Congress has not expressed an intent to preclude state court jurisdiction. The court in Mansell found that this distinction is significant where Congress exercises its plenary power to deprive state courts of jurisdiction over a particular subject. State court judgments purporting to exercise jurisdiction over the preempted subject are nullities and vulnerable collaterally. Whereas in McCarty, the court interprets Congress's actions as superseding or overriding state law. This judicial finding of conflict does not necessarily imply a withholding of subject matter jurisdiction, and the enforcement of conflicting state judgments may be avoided only by direct appeal. In its analysis, the Mansell court on remand concluded that the preemption recognized by McCarty fell within the second category and that no withholding of subject matter jurisdiction, express or implied, could be found. The judgment entered in McCarty was not void for want of subject matter jurisdiction, nor was the judgment at issue in the matter of In re the marriage of Mansell found to be want of subject matter jurisdiction. The court held, where a state specifically inhibits an act, it is an error for the court to do the thing prohibited. But if the Constitution has conferred upon a court the power to deal with the subject matter, and if jurisdiction over the parties has been acquired pursuant to the exercise of due process, the judgment is valid and is conclusive, however erroneous, unless reversed on appeal. If a trial court, such as the one in this case, in the exercise of its jurisdiction, enters a judgment of divorce affecting property rights of the parties, contrary to federal statute, the trial court is guilty of an error of judgment. Such an error does not render void the judgment. As this court held in Jackson City Bank and Trust Company versus Frederick, there is a wide difference between want of jurisdiction, in which case the court has no power to adjudicate at all, and a mistake in the exercise of undoubted jurisdiction, in which case the action of the trial court is not void, although it may be subject to direct attack on appeal. Justice Viviano, in his concurring opinion, noted, importantly in a footnote, the Mansell court discussed the state court's application of the doctrine of res judicata. Although the court ruled in Mansell that federal law prohibited dividing military disability retirement as community property, the court's opinion also established that res judicata could prevent the reopening of the property settlement and that res judicata is a matter of state law. Under res judicata, the Court of Appeals in Mansell on remand affirmed the prior order enforcing the division of the husband's military disability retirement as community property, despite the fact that it contradicted federal law. As Justice Viviano went on to note, the denial of the second petition for certiorari shows that footnote 5 is more than mere words. The court did not merely state in the abstract that the division of military benefits under state law principles of res judicata were outside the scope of federal appellate jurisdiction. It refused to reverse or even review on the merits a state court decision applying these principles. I submit that Mansell, like McCarty, did not deprive state courts of subject matter jurisdiction. It merely required that veterans' benefits be divided exclusively under federal law. If the Supreme Court had any intention of treating Mansell as a jurisdictional holding, it likely would have granted certiorari. By denying review, the Supreme Court accepted the California court's reasoning that Mansell was a rule of substantive law and not a rule of jurisdiction. The court in Howell makes no reference to the issue of subject matter jurisdiction, so that opinion is not particularly instructive as to that issue. However, as I noted, in the matter of In re Mansell, the court recognized that there were two distinct categories of preemption. The second category found to be applicable is where state and federal law are so inconsistent that state law must give way because it impedes the accomplishment and execution of Congress's full purpose and objectives. In Howell, Justice Breyer, writing for the court, stated, in Mansell, the court held that federal law completely preempts the state from treating waived military retirement as divisible community property. He also stated that regardless of mere form, reimbursement and indemnification orders displace the federal rule and stand as an obstacle to the accomplishment and execution of Congress, and that all such orders are thus preempted. Justice Breyer did not state that reimbursement and indemnification orders were examples of state courts improperly exercising jurisdiction over a preempted subject. Instead, the language used by Justice Breyer suggests that the applicable federal law supersedes or overrides state law, in that particular instance, as it did in McCarty and Mansell. And therefore, there is no withholding of subject matter jurisdiction, express or implied, in the Howell opinion. Justice Viviano, in citing Office Planning Group versus Barraga Houghton Keweenaw Child Development Board, recognized that it has long been established that so long as Congress has not provided for exclusive federal court jurisdiction, state courts may exercise subject matter jurisdiction over federal claims whenever by their own constitution they are competent to take it. It was noted that where Congress has designated another forum for the resolution of certain classes of disputes, such designation deprives the courts of jurisdiction to decide those cases. Appelli argues that Congress has created an exclusive, comprehensive regulatory and judicial authority over all claims regarding military benefits to the exclusion of all other courts. Appelli states notably that Section 38 U.S.C. Section 2111, now Section 511, was explicitly changed after the United States Supreme Court decision in Rose v. Rose to address any ambiguity regarding the exclusivity of the VA's jurisdiction vis-a-vis state courts. The stated purpose of the Department of Veteran Affairs is the administration of laws providing benefits and other services to veterans and the dependents of veterans. There is no language in the statutes referred to in this case that by enactment of this legislation, Congress intended expressly or impliedly to prohibit state courts from exercising jurisdiction over the adjudication of claims regarding the division of military benefits or the extent to which they should be considered as part of the marital estate. Appelli seems to be arguing that the passage of the Department of Veteran Affairs Act and the Department of Veteran Affairs Codification Act means that Congress now occupies the entire field regarding all issues concerning military benefits of any kind. Yet the court in Howell, which was decided in 2017, never reached that conclusion in the context of a case involving the dissolution of a marriage and the state court's ability to enforce a divorce decree by imposing a restriction, reimbursement or indemnification order. Appelli is correct. Federal law does provide a framework for determinations regarding the eligibility for military benefits, especially disability benefits, and state courts have no subject matter jurisdiction over the determination of whether a veteran is eligible for disability benefits, any more than state courts have subject matter jurisdiction over bankruptcy claims, labor claims brought pursuant to the National Labor Relations Act, or issues governed by the Federal Energy Regulatory Commission. State courts, however, do have subject matter jurisdiction over domestic relations cases, and as the courts in McCarty and Mansell have held, if there is an instance in which a question of federal law would apply, the state court must apply the federal law. The failure to apply federal law is a legal error and not jurisdictional conflict. The appellant in this case did not avail himself of a timely appeal and therefore should be precluded from challenging the validity of the divorce decree nearly 6 years after it was entered by appealing an order holding him in contempt of court. This court should reject appellee's argument that the circuit court does not possess subject matter jurisdiction to enter the terms of the party's consent judgment of divorce, and also find that appellee's sweeping assertion that all types of federal preemption deprive state courts of subject matter jurisdiction as wrong as a matter of law. The decision of the Court of Appeals finding that the trial court lacked subject matter jurisdiction over appellee's disability benefits, rendering the judgment of divorce void and therefore subject to collateral attack, should be reversed, and the judgment of divorce and all orders related to the enforcement of its terms should be affirmed. Thank you,
counsel. Thank you very much. Mr. Tucker.
Thank you. Thank you. May it please the court. My name is Carson Tucker, here on behalf of Ray Foster, the appellee in this particular iteration of the case. I'd like to address Justice Zahra's question. How do we distinguish, if there is a distinction, those matters over which state courts do and do not have subject matter jurisdiction when we're addressing issues of federal preemption? My position in my brief, as I've laid out, is I think any situation in which you have statutory preemption, state courts lack the authority to rule over issues that are touched upon by that federal statute. This court has held already unanimously that 38 U.S.C. 5301 is the statute that applies to the consent judgment in this case. That statute and the specific subsection A3, A, and C actually voids from inception any agreement or any assignment based upon such an agreement, which again, this court already unanimously held applied to this case. Now, notwithstanding that this is a federal statute passed pursuant to Congress's enumerated powers, which are plenary over all matters concerning military benefits and preempt state law under the Supremacy Clause, the provision that it is void from its inception, I believe, prohibits the court from applying any basic judicial doctrine of convenience like res judicata or collateral estoppel to the arguments here. I think we can raise that issue at any time, as the Michigan Supreme Court held in Strauss versus Governor, based upon the voidness of this particular provision. Can you excise that provision and that rule of federal preemption from the ordinary state court domestic law issues in a divorce proceeding? And I would submit that you can. And in fact, I would submit that you must in this case, because federal law always preempts state law. If we could allow doctrines of judicial convenience to override the basic premises of federal supremacy under the Constitution, then we could pick and choose when we would like to do that. This is a unique case. Ordinarily, state courts have subject matter jurisdiction over state law issues concerning family law and divorce. We're not saying that they don't, but the court certainly cannot rule upon an issue that it does not have authority to do. The Supreme
Mr. Tucker,
Court.
let me interrupt you as well and see what questions my colleagues have for you. Thank you very much, Justice Zahra. You're muted, Justice Zahra.
Well, I'm the one that gets charged with being guilty on that offense today.
Only the first one. We'll see.
That's right. So I guess I appreciate you delving into my question, but it seems to me that there is a difference between the initial determination of benefits and then proceedings that would impact those benefits. And I think that's what opposing counsel was suggesting in applying the first question under the Marshall versus Consumers Power case, that ultimately the determination of benefits is something of federal question, but proceedings that relate to division of them, particularly in divorce, is still something that is permissible under state law. Why is that not accurate? You're essentially telling me because this is a federal question, it's preempted. I mean, if I'm oversimplifying your answer, please enlighten me.
It's, of course, state courts have a jurisdiction to address federal questions. No question about that. That is true. But if federal law in the form of a statute, which this court has already ruled applies in this case, actually removes the authority, which the Supreme Court said in Howell, 137 Supreme Court at 1405, Section 5301 removes authority from the state courts to vest these particular benefits in anyone other than the beneficiary. That removal of authority is equivalent to a lack of jurisdiction. If you look at the case of Veterans versus Common Sense, Veterans for Common Sense versus Shinseki, 678 F3rd at 1023, any adjudication of any state law claim for these particular benefits would necessitate a consideration of issues of law and fact involving a decision to reduce those benefits from the beneficiary, the veteran, and dispose of them in some other matter. That is a question that is specifically addressed by the statutes here, not only Section 5301, but Section 511, which again was amended to give exclusive jurisdiction to an Article I tribunal to make all those decisions. Now, going back to the original part of your question, I think Supreme Court of Michigan precedent clearly creates a three-pronged inquiry over jurisdiction, which allows us to avoid this issue of, okay, state courts have subject matter jurisdiction over the general action, which we don't disagree with. And if once they have that, they can rule on any matter that's before the court. And if they make a decision that's wrong, then you have to appeal it timely or subject yourself to the state court rules for a motion to set aside a judgment timely, or as that provision allows, or you cannot collaterally attack or res judicata may apply. But that is not the situation here, because the three-pronged inquiry, if you look at Driver versus Union, which I cite extensively in my brief, which goes back to many US Supreme Court cases, Ex parte Rowland, Windsor versus McVeigh, there's actually a three-pronged inquiry. And Judge Freeman, in his famous treatise on judgments, says there's a three-pronged inquiry. Does the state court have the authority to address the issue that is before it? And I would submit that here, given the Supreme Court's statements in not only in McCarty and Mansell, but in Howell especially, the Supreme Court has clearly said that McCarty, with its rule of absolute federal preemption, still applies. Ridgway versus Ridgway, which is another 1981 case, which was basically parallel to McCarty, it said, we understand that state courts generally have subject matter jurisdiction over all issues of family and domestic law, except where Congress has basically said they do not under the enumerated powers in the Constitution. Now, I want to, addressing your question, but also Justice Bernstein's question. Happy birthday, Justice Bernstein, by the way. This is a different type of pay. Okay, so Mark McCarty was just addressing military benefits in general, and specifically retirement benefits. So the court in McCarty was addressing whether or not and to what extent state courts could exercise jurisdiction over military retirement pension. Fast forward to Mansell, 1989. Mansell was addressing whether or not state courts could exercise jurisdiction over the amount of waived retirement pay that was disappeared from the former spouse's share because the military member waived a portion to receive some disability pay. Mansell did not address disability pay per se, which is what we're addressing here. Mansell also did not address the application of 38 U.S.C. 5301. And in fact, expressly in a footnote, it says we're not addressing whether 38 U.S.C. 5301 applies to the particular issue here. So McCarty and Mansell are only somewhat helpful. Howell addressed 100% pure VA disability pay. That type of pay is what my client is receiving. That type of pay is what the VA has exclusive jurisdiction over, because remember, these are federal appropriations specifically appropriated to benefit the beneficiary veteran for his or her disabilities. These are enumerated powers of Congress that gave the VA the exclusive jurisdiction over all questions of law and fact with respect to a division of those benefits. So that jurisdiction has already been taken by the VA. If as
Mr.
the
Tucker, let me
Supreme-
make sure Justice Zahra had his questions answered. And I don't mean to interrupt, but I want to make sure everybody has time
Okay.
to ask whatever questions they have. Justice Zahra, were you satisfied? Do you have additional questions?
I have no additional questions. Thank you.
Okay, and I appreciate that you already started answering Justice Bernstein's questions, but you can't skip over Justice Viviano. So Justice Viviano might have some questions.
Yeah, thank you, counsel. My question is, if it's your position that the state courts don't have the authority to make decisions about the division of military pension and disability benefits in divorce actions, who has that authority? What court or agency should be making those decisions, in your view?
So if you look at the basic principles of federal preemption under the Constitution, the states ceded sovereign authority over all questions of congressional appropriations regarding military benefits when they signed on to the Constitution. That from that point forward, Congress can say when and when not the states may exercise any authority.
Let me just jump in. I don't
I'm getting
contest
there.
that the Congress could establish an exclusive federal forum for the decision of federal questions when it wants to, and as counsel has alluded to, it's done that with the NLRB and with FERC. The question I have is what is the forum here that you think that this, if you're saying this should not have been decided in a state court judgment, the implicit in your assertion is that it should have been decided somewhere else, right?
It's already been decided somewhere else. The VA has already made a decision with respect to this.
Does the VA have a department that handles divorce cases?
The VA, yeah, it does. It has a process called apportionment. 38 USC 5307 allows the VA to exercise jurisdiction over questions of support to dependents and family members that are made upon an application. There's an Article 1 tribunal, not an Article 3 court, but an Article 1 tribunal that is designated to deal with those types of questions. It's
it allows them to, and
the onus is on.
You said it allows them to under the law that you're referencing. Does it make the VA the exclusive federal forum?
It absolutely does. It absolutely does. If you look at the language of the statute, Section 511 of Title 38, which must be liberally construed in favor of the veteran beneficiary, that's a principle that has been stated multiple times by the United States Supreme Court. I don't even think you need to.
If I look and call the VA, I would expect they would be handling thousands of these divorce cases. I mean, so the practitioners would be familiar with this because it would be a well-traveled route, right?
You'd
stop your divorce action because it involves a federal military disability pension benefit division, and then you'd have to go over to the VA and have them resolve this issue, and then you come back to the state court and it would be included in the judgment. Is that what you're saying? That's how this works?
That's the proper jurisdictional approach for questions concerning claims by dependents for support. Now you have to remember, this case is not about dependency support. This case started off as a division of property assets, which the Supreme Court has said on multiple occasions is fully preempted. If you look at the Supreme Court case Hillman versus Moretta, 2013, they cite every single case, McCarty, Ridgway, Wisner versus Wisner, that dealt with Congress's preemption over the state courts regarding all questions concerning benefits given over to federal employees in that case. But those, they cite all of the veterans cases. They say Congress has fully preempted the field in this area. States have no authority to make decisions that are contrary to the statutes. Now, if you overlay that with 38 USC section 511, which was amended after 1987, that statute specifically says the VA has exclusive jurisdiction over all questions of law and fact with respect to a claim for the particular benefits at issue in this case, which are pure disability benefits. They cannot be considered property.
Let me just ask one last question. I mean, I'm not, maybe I just haven't practiced enough family law, but I'm not familiar with this procedure whereby a divorce action stops and people run over to the VA to have these issues determined. But let's assume that your theory is correct, that that's how this not only is supposed to happen, but that's how this happens, at least in some places in the country where they do it correctly under your view. Wouldn't we expect then there to be lots of appellate decisions in the federal courts where people are challenging the VA's determinations?
You might expect that, Your Honor, but the reality of the situation is that in 99.99% of the cases where it is done correctly, and the former spouse or the guardian of a dependent requests an apportionment as they are supposed to through the tribunal with exclusive jurisdiction over that question for those benefits, the VA will say generally no. And there will be or may be an appeal to the Court of Claims of Veterans Appeals, which is the Article 1 tribunal designed by Congress to deal with those issues. But the reality is the Veterans Administration is doing what it's supposed to do. Those federally appropriated funds are for the disabled veteran. They're not for anyone else in any other circumstance. 42 U.S.C. 659, the Child Support Enforcement Act, lays out the differences in the types of benefits that I'm talking about. It talks about retirement benefits. It talks about disability pension.
I don't think anybody contests that federal law is preemptive in this area, which means federal law controls. The question is whether it deprives the state divorce court, family court, over jurisdiction in the division of marital assets. That's the question. So anyway,
So Section 5301, which this court already had, which is law of the case, right? I mean, unanimously, this court held that that provision applied. It says these agreements are void from their inception. So I don't know how the court can use a doctrine of judicial convenience, which all res judicata is, to actually supersede federal preemptive statutory law, which clearly says it's void from inception, and which the Supreme Court.
You think the Supreme Court just dropped the ball then in Mansell when it didn't? It didn't sort of treat res judicata with the disdain that you're treating it with, or you want us to treat it?
So it's not disdain, Your Honor. I submit respectfully. If you look at the actual doctrine of res judicata as it applies in this substantive matter.
The question was about Mansell. Did the Supreme Court, when they allowed the state court there in California to do exactly what you're saying we should not do under the doctrine of res judicata, how do you explain that?
Recall the premise of my brief, which is actually what I started off with in responding to Justice Zahra's question. The premise of my brief is Mansell, McCarty, none of those cases prior to Howell ever applied Section 5301 to the disability pay. This is a federal statute. Certainly the federal statute is greater in terms of hierarchy to res judicata. Mansell did not apply Section 5301. Mansell wasn't even addressing the specific disability benefits that we're talking about here. So Mansell is of very little value in answering that question. I think the question is, does this court's decision...
Let me back up and ask one last question. Is it your view then that state courts, when they include in judgments the division of military pension benefits, are acting without power, without jurisdiction? I mean, that's something that I think is routinely done. Are you saying in all such cases, those judgments are all void because the family court has no authority to do that? And those decisions can only be made by the VA?
Of course not, because in a situation where it is applied, in a situation where the USFSPA applies, as here, 10 U.S.C. 1408, Congress actually lifted that absolute preemption and jurisdictional bar and gave the state courts authority to divide up to 50% of the very specific pension benefit that you're talking about. So no, it's not my position at all. State courts can certainly divide that which federal law by statute allows them to divide. Disability pension under the USFSPA, military disposable retired pay, and disability pension under the Child Support Enforcement Act, but not pure VA disability pay under 42 U.S.C. 659.
Your view is, I mean, I don't want to mischaracterize your view, so tell me if this is not right, that the state court has jurisdiction to divide these benefits as long as it does so correctly?
Correct. As long as Congress gives them the authority to do it, they have the authority to do it.
If they make a mistake, then they lose their subject matter jurisdiction and the judgment's void?
It's under the principles that this court has espoused in many of its cases, including the Driver case and the Adair case. The third prong of jurisdiction, subject matter jurisdiction, is whether the court has authority over the issue under it in question. And I think this court's decision...
Not usually how jurisdiction works. If you have the power to decide the question, that is to decide it rightly or wrongly. But anyways, I'm monopolizing the time, counsel, so I'm going to cede back my questioning so that my colleagues can have a chance to ask you some questions.
Sure.
Thank you. Justice Bernstein.
Hi, counsel. Good morning. I just want to ask one question as a follow-up to Justice Viviano's line of questioning. What would an opinion from this court do in terms of the impact it would have on these jurisdictional questions? And how would this affect further future cases?
So as far as it affects future cases, I think the question has already been answered by this court's unanimous opinion. You overruled McGee versus Carmine. You said that Howell and McCarty always applied. So going forward, and you would advise practitioners that they can't allow an agreement to be entered into that would be violative of the federal statutes that prohibit military veterans from dispossessing themselves of their benefits, whether it's through disability or non-disposable retired pay under the USFSPA. They cannot enter into those agreements because they're prohibited by this section 5301. That was clearly stated by this court. So going forward, that would be the answer. As far as the cases that are in existence now, I think, the bottom line is federal law preempts state law. 5301 voids from inception all agreements or assignments that are based upon such agreements to make or force the veteran to dispossess himself or herself of these benefits. So those are clearly void and should be subject to collateral attack and principles of restitution, because this court has previously held common law restitution would apply to a situation in which a contract is void from inception, which is what we've pursued in the lower court after the Court of Appeals opinion. So I believe the Court of Appeals cited a litany of cases, not just cases in which there's a federal forum exclusively addressing the very issue, because this court's case law clearly has three prongs of subject matter jurisdiction. In this case, the third prong, authority over the issue, is not present. It was not present in 2008, and it's certainly based upon this court's decision applying 5301. You can't go back and say it's void from inception. I hope I answered your question, Justice Bernstein.
You did, counsel. Thank you very much.
Justice Clement.
No questions, thank you.
Justice Kavanaugh.
No questions.
Justice Welch.
No questions. I think they were covered. Thank you.
And I have none either, Mr. Tucker, because you did a nice job in response to all the other questions. You have both used up more than your time. Thank you very much for being here. The case will be submitted.
Thank you.